be seated. Call now ACOSTA number AP 77095, Brandon Day McCALL versus the State of Texas.
May it please the court. My name is Doug Parks. I'm from Wood County. This is an appeal of a death penalty case out of Collin County. I want to start with point of error number one, which involves jury selection and our contention that the court erred in denying defense challenges to four specific jurors. And just to make sure that we're clear, the defense did use all their strikes. We requested additional strikes, were granted 2 additional strikes. The 18th request, or the request for the 18th juror, was denied. That juror was seated and was identified as an undesirable juror, along with several other people. So we believe that certainly that the error has been preserved. I don't want to get into the weeds with each individual juror. I think I would be wasting the court's time to do that. I believe that the appellant's brief and the state's brief sets out pretty clearly what our positions are, and it will help us a great deal to argue over what was said or wasn't said on the record. The record's there for the court to make the determination. We don't need to talk about that, I think, this morning. What I do want to talk about, though, is this. I understand that in issues of this kind, great deference is given to the trial judge in making a decision about whether or not to grant defense challenges for cause, and is reviewable only for an abuse of discretion. And I want to talk about abuse of discretion mostly this morning, because it's our position that the record pretty clearly shows that the court in this case was hostile, to say the least, to the defendant and to the defendant's defense. And rather than go through each individual juror, I will try to point out to you where in the record we believe that contention has merit. And I want to start right at the end of the trial. After the trial was over, the jury returned a verdict that required the court to sentence the defendant to the death penalty. After he received the verdict, the judge made a speech to the members of the jury. It's in the record, volume 47, right at the end, prior to sentencing. In that speech, he praised the Richardson Police Department. He praised law enforcement generally. He praised the prosecutor and the defense and the district attorney's office, and he even gave a slight nod to the defense lawyers and made a nice long speech. When he had finished that speech, he turned to Mr. McCALL, and essentially, the only way I know to put it is dedicated the sentencing to the victim, in this case, Police Officer David Sherrod. He said, "Mr. McCALL, this is for David Sherrod." And he then proceeded to sentence him formally to the death penalty. Now, it's clear in the record. What's not clear is the tension in the courtroom at the time and the drama involved, if you will, of that. Now, I want to make myself perfectly clear. I don't disagree with anything that the trial judge said in his speech to the jury. I think we can all pretty well agree with everything that he said. The question is not even whether it was appropriate for him to make a speech of that kind at that time, or whether it was appropriate for him to dedicate sentencing to the victim by name. What's relevant to our situation here this morning is that it shows his heart and his mind at that time and as it was throughout the course of the trial.
Counsel, what evidence do you have to show or point to during the course of the trial that the trial judge was unfair in any way to your client?
I'm sorry, Judge. Unfortunately, I've gotten a little hard of hearing.
Do you have any, can you point to anything during the course of the trial that indicated that the trial judge was unfair to your client during the course of the trial?
I'm just getting there. I started at the back, and I'm
Okay.
looking forward.
All right.
So, in the trial itself, I have no particular examples except in the jury selection process. And during that process, the judge had, he interrupted defense voir dire. He argued with defense counsel, and I'll talk about some of the things that he did, and just showed hostility, I guess is the best way to put it, both to the defendant and to defense counsel. And well, and one of the issues that I have in the brief is the one where there was a dispute over the meaning of beyond a reasonable doubt, and whether 100%, just a statement of 100% proof, I would require 100% proof from the state. Well, that, we've alleged that, of course, I'm kind of getting ahead of myself. The state granted, the trial judge granted the state's challenge for cause on that issue. But the judge involved himself in that voir dire, arguing with defense counsel over what 100% meant or didn't mean, and he erred. I think he and the defense counsel, at least early on, misstated what, that's a bigger issue and it's used a lot in trial courts. But 100% of the reasonable doubt is required by law. Now, the judge took that particular juror on voir dire himself, did not explain the law to the juror, did not tell him what the court's charge would say, didn't tell him that the court's charge would say that the state was not bound to prove their case beyond all possible doubt, but was required to prove it beyond all reasonable doubt. And there was never any distinction between reasonable doubt and possible doubt, because we all know that some things are possible but are not particularly reasonable. And since we don't have a definition of beyond a reasonable doubt, the juror was perfectly in her right to say that they had to prove to her to 100% of her satisfaction.
Counsel, I appreciate that you're making a very good case about trial court's attitude to parties, but what specifically is there that you're pointing to that says these jurors?
Okay. In this particular case, this was a juror that the state didn't want. He involved himself in that voir dire, and not only did he disqualify the juror on the 100% issue, he covered his bases by sua sponte, saying that she was a vacillating juror and the state hadn't submitted her on that issue. He just did it on his own, and that juror was gone. Another incident that is not in the brief at all because there was no error involved, but there came a time when defense counsel, toward the end of voir dire, when it was getting pretty close. As I recall, there were 4 jurors to get. State and the defense had about 4 strikes left. And as a trial lawyer, I can tell you that, if possible, you never want to have fewer peremptory challenges in your quiver than there are empty seats in the jury box. And it was 4-4 at that point in time. So we had a juror that we did not particularly like on paper, but we realized we might have to take her because there were people coming worse apparently than she was down the line. This was a case that depended on mitigation. There was no close call as far as guilt or innocence was concerned. I'll be candid about that. Mr. McCALL killed a police officer, and his friend barricaded himself in an apartment and was arrested at the scene. And there was video. And there was very little chance that we were going to prevail on a future dangerousness issue. So we had to have jurors, if we had a chance at all, we had to have jurors who had an open mind, if you will, to the mitigation issue. And defense counsel was trying to educate that juror on that issue and what her rights and responsibilities were, and that she could make her own personal moral judgment about whether life or death is the proper punishment.
Counsel?
That irritated the
Counsel,
judge.
in your brief, could you explain to me a little bit, you make a sort of a distinction between possibility and chance. Could you explain the law regarding that with regard to the challenge for cause?
On that particular issue, the judge took the position that the juror had a right to define probability for himself. And he defined it as possibility or chance. Now, there's no dispute between the state and appellant that that's not right. That the court has clearly said that whatever else probability may mean, it's more than a mere chance or possibility. The state told that particular juror that very thing and explained that, I say explain the law to them in that regard, or to him in that regard. Still, he persisted. And the judge denied the defense challenge for cause on the basis that the judge had a right, the juror had a right to determine for himself. And again, I think that's an example of clear abuse of discretion. The law is clear in that regard. And I'm looking at my time, and I want to very badly talk about issue number 8. This was a situation where the defense was shut down trying to ask questions to make a determination whether or not a juror saw or did not see a nexus between the commission of the offense and the definition of mitigation, the statutory definition of mitigation. I'm not going to get into weeds about that. There are issues in the brief about it. But here's what our contention about that is. This court has told us 3 things about the definition of mitigation. The first thing you've told us is that if the definition of mitigation required a nexus between the proffered mitigation evidence and the commission of the offense, the definition would be unconstitutional. You told us that in Kabul. In Kabul, you also told us that this court did not see a requirement for a nexus from the definition of mitigation as set out by statute. And the third thing that you've told us in Kabul is that you did not believe that any reasonable juror would see a nexus between the plain language of the definition of mitigation and the commission of the offense. Now, of course, we know the definition doesn't say the issue is this. That may all be true. But it is the defense's job to find out whether this is a reasonable juror or not, whether or not this person does in fact see a nexus from the definition of mitigation to the offense. And if that person does, then they should not be qualified to sit because they would return a verdict contrary to the Constitution. It's said from Tenard and even Kabul. So we were trying to find out from that juror whether or not they could follow the law, that is, not require a nexus between the mitigation evidence proffered and the commission of the offense. The state continued to shut us down by objections that there were commitment questions. But they weren't commitment questions. They were attempting to determine whether or not the juror was qualified, and that's never a commitment question. So we were not able to learn whether or not this person could follow the law as is, and consider blameworthiness to be a holistic sort of determination, or whether they were going to require a nexus. And I've picked enough of these jurors that I have heard so many times when we get down to this point, a juror say, well, you know, yes, I can consider his blameworthiness if it was self-defense, or if it was an accident, or if there was some kind of provocation, and you have to start all over. Because these folks don't realize what we realize. They don't do this for a living. And it's hard to get across to them what's required. And we believe that, taking into consideration all of these issues, this judgment of death should be reversed and returned to the court for a new punishment hearing.
Thank you,
Thank you,
counsel.
Your Honor.
May it please the court, Lisa Braxton for the state. I wanted to notify the court at the outset that I am not actually the author of the state's brief. The author was Sarah Preston, who left our office about a month ago to join the U.S. Attorney's Office. However, I have reviewed the brief. I also edited it after she drafted it, so I'm familiar with the case, the brief and the record, and I'll do my level best to answer any questions you may have. However, I'm planning to keep my remarks brief because, as Mr. Parks noted, both briefs very specifically address the particular claims about the challenges for cause and the court's rulings on them. And so it would be a pointless task to do the same thing again here this morning. I would like to note, however, that the jury selection in this case was much like jury selection in any other death penalty case. Hundreds of people get called down to the courthouse, and these people often have very little, if any, familiarity with criminal law. They get a 20-page questionnaire that they spend an hour or more filling out. Then they get a crash course in death penalty case law. And then they get to take a pop quiz, and they do it by themselves in a room full of attorneys. So it's not surprising that these individuals are often inarticulate or less than articulate in their responses to questions, or that they have difficulty verbalizing their understanding of the law and their opinions about that law. Plus, you have lawyers on opposing sides who are either trying to elicit answers that will exclude the juror or insulate the juror from a challenge for cause. It's the judge's role to sift through all of this and find the truth as he perceives it to be. Can this person understand the law and apply it fairly in this case? And that's exactly what the judge did in this case. Now, I will note, and this is not in the record, this was Judge Roach's first death penalty trial, his first jury selection in a death penalty case. He spent a significant amount of time prepping for this, and he himself conducted the pick. As Mr. Parks knows, the judge did have some remarks to make at the end of trial. Those remarks, however, were based on the evidence he heard in the courtroom about the crime that was committed. It in no way evinces a personal bias towards Mr. McCALL or his counsel. And I also disagree with Mr. Parks' statements that Judge Roach was in any way biased towards him personally throughout the rest of the trial. I think that just as in any case, we don't always agree with the judge's rulings, especially when they're against us. However, Judge Roach also granted several defense challenges for cause. He was not a prosecutor on the bench. And as Ms. Preston's brief clearly shows, there was substantial record support for the rulings that he made. Each one of the jurors that the defense challenged for cause made numerous statements on the record indicating their understanding of the law and their ability to follow it, or, as in the case of Mr. Brasher, they simply weren't informed properly about what the law was. And faced with this information, the judge made the proper call. He decided that these jurors could in fact follow the law. To the extent that opposing counsel disagreed, he had peremptories to exercise, and he used those.
When the veneer persons were informed about what the law actually is, did they, to a person, indicate that they could follow it?
Yes. Well, Brasher was not informed on the law about probability and possibility, but in every other respect, all of the jurors were adequately informed about the law by the state or the defense, and they all demonstrated a willingness to set aside any personal feelings they might have and listen to all of the evidence presented at trial in reaching their verdicts. As I said before, these are people with no exposure to death penalty law. They're doing their level best to understand concepts that are even difficult for us lawyers sometimes. And I think they showed repeatedly that they were able to follow the law. And that's why the judge denied the challenges for cause. With respect to issue 8 about the restriction on voir dire, the state disagrees that the trial court's ruling was improper. The judge has discretion to limit improper questioning. And in this case, he did so because the question actually misstated the law. The question was, if you have a reason, imagine you have a reason in your mind that makes you want to answer this mitigation special issue yes. But that reason doesn't reduce the defendant's moral blameworthiness. How are you going to answer the special issue? That's simply not a scenario that is ever going to arise. It assumes there's a conflict between moral blameworthiness evidence, what constitutes moral blameworthiness evidence, and what constitutes mitigation evidence. It assumes that we can't consider evidence outside of moral blameworthiness in answering the special issue, and that's simply not true. As this court has said repeatedly in its precedent over 2 decades, there is no conflict between the definition of the mitigation evidence and the special issue instructions, which specifically tell the jurors to take into consideration all of the evidence, including the circumstances of the offense, the defendant's character and background, and the personal moral culpability. Moreover, the defense was in no way limited by in their ability to explore the idea that the jurors might have difficulty or might be unable to consider all the evidence in reaching their answer to the special issue. He was not prevented from asking them questions about their opinions about this various types of evidence or their ability to consider all the evidence, once again, after a guilty verdict. In fact, he spent a substantial amount of time doing so. And lastly, the state in no way suggested to the jurors in its voir dire that they should restrict their decision on the mitigation special issue to moral blameworthiness evidence. It simply didn't happen. This is something of a red herring here. I have no further comments to make, and I'm happy to yield the rest of my time to the court unless there are any questions you have for me.
Thank you, counsel.
Thank you.
I'm just going to take a minute. I agree that sometimes Judge Roach did grant state defense challenges for cause. One of those situations when there was a juror named Laura Brazil, it can be found in volume 26, page 157 through 163. And I got a little bit sidetracked earlier when I was going to talk about it. This was a woman that we didn't really like, but we thought we were going to have to take. The judge took over. I asked a question that I thought was particularly proper at the time. And I asked this question. If you found mitigation, whatever that might be in the case, and you found that that mitigation was sufficient in your own mind to warrant life rather than death, could you vote that? And she said yes. And the judge interrupted and said, "Ma'am, I have a question for you." And then he interrogated her for about 3.5 or 4 pages about what her morals were, because she had mentioned the word morals and what that would have to do with her decision-making process, and went on and on and on about it. Finally, she was turned back to me. The defense counsel is me. And very promptly, she wasn't a dumb woman. She very promptly decided that she would automatically answer special issue number 1, yes, although she had denied that through the state's voir dire, and so was disqualified. And the court, of course, granted our motion to excuse her. We had to at that point. After that was done, the judge let in on me for wasting the court's time and taking an hour and a half to lecture a juror and that he was not going to sit on the bench and listen to me lecture for an hour and a half. Well, in the first place, I only had 45 minutes. And in the second place, I was educating, or thought I was, or trying to. I wasn't lecturing. I was asking questions. I only say this, and I know it's going to maybe sound personal because I was the lawyer involved. It's not personal. It does, however, I believe, give a pretty clear picture of judges' attitude, not just with that juror. It started pretty early. Now, I can't, there's got to be some common sense used here based upon what he said in the record. And all I'm asking the court to do, really, is to take that into consideration when you're making a determination about whether or not he abused his discretion, that that's something that the court should make its own judgment about based on the entire record, because that's what the law says, that considering the entire record, did the judge abuse his discretion in making these errors? We suggest that he did, and I appreciate the court's attention.
Thank you, counsel. The case is submitted. Call now cause number AP 77092.
Good morning, and may it please the court. My name is Janae Sforgula, and along with Kevin Trahan, I represent Hector ACOSTA, who is appealing his capital murder conviction and death sentence out of Tarrant County. Today, I'll be arguing the first point of error in our brief, in which we contest that the Miranda warnings provided to Mr. ACOSTA before he was interrogated were inadequate. And the dispute here really centers around what Miranda requires law enforcement to inform the accused about their right to counsel prior to interrogation. So under Miranda, the accused, it must be told that they have the right to counsel, and that if the accused, quote, cannot afford an attorney, one will be appointed to him prior to any questioning if he so desires. The warnings given to Mr. ACOSTA, translated from English into Spanish, did not convey this information. Instead, after Mr. ACOSTA was told that he had the right to a lawyer, according to the state's translation, he was then told, quote, if you cannot hire an attorney, you have the right to have an attorney hired. And I want to just briefly start by laying out the standard that the courts use.
Let me just interrupt you.
Yes.
How was it determined that was said? Was it through the testimony of an interpreter?
Yes, Your Honor. The state,
Specifically the last word, hired.
yes, Your Honor. The state asked an interpreter, his name was Manuel Murillo, to transcribe the warning in Spanish and then to translate it into English. So that word hired came from the translation that the state requested.
When was that obtained?
I'm sorry.
When was that obtained, that translation? On the site or later?
It was, I believe it was obtained later. He had a video of the warning and watched it and transcribed it and then translated it. So it was before the pretrial suppression hearing, but it was not sort of contemporaneous with the warnings being given.
So the warnings were just given in English or in Spanish at the time?
Yes, they were given in Spanish at the time,
Okay.
and so then this is the later translation into English.
But, okay, so who was providing the translation? It wasn't the officer who was doing that, it was...
Oh, I understand your question
Yeah.
now. Yes, the translation from English into Spanish, the translation that was given in Spanish was provided on a card that the Arlington Police Department uses. It's one of, I think, 3 different cards that they have.
So does that mean then that if we decide that you're right about this, then we're going to have a whole lot of other cases from your county where this problem's going to arise because this same translation is being given over and over and over again?
So, a couple of things on that note, Your Honor. One is, this would be only the Spanish translation, so it would only be defendants who are being Mirandized in Spanish, which is presumably a small percentage of the people being Mirandized. And then another point is that, this isn't the only translation that's used by this department. And I will just say, since this is out of Tarrant County, we looked at the Fort Worth Court of Appeals for opinions challenging this translation and didn't locate any. So, the record, there isn't any information in the record on that point, but this isn't a warning that has come up.
Is there any indication that the officer who was reading the card knew that it was wrong?
On the record, he said that Miranda doesn't require you to hire an attorney, but what he said is he read the card.
Was the card, I've seen cards before where you have the English on one side, Spanish on the other side. Was the card introduced into evidence?
A photocopy of it, of just the Spanish side of the card, so I'm not sure what was on the back side of
So
it.
what do you say would have been the proper word for appointed? What would the Spanish word have been?
I'm not fluent in Spanish, so I can't provide that specific word to you, but I do think, there are a couple of examples from the state's brief of translations of Miranda warnings that were given in Spanish and then later translated into English that do demonstrate that the concept of the idea, let me answer that question. The concept of the idea in the fourth warning can be absolutely conveyed in Spanish. So one of those examples is the United States versus Soria Garcia, which is out of the 10th Circuit. And there were actually competing English translations in that case, but both of those translations conveyed the idea that an attorney would be provided for free, and I can tell you what both of those are. One was, if you don't have the money to employ a lawyer, one will be appointed to you before answering any questions if you so decide. And then the other translation offered was, if you do not have the money to employ an attorney, one can be obtained for you before we ask you any questions if you so desire. And then there was just one other example out of the Houston Court of Appeals. There was a dispute over whether the warnings were adequate, or actually whether the statement was, the waiver was voluntary. And that was in Cervantes Garcia versus State. And the warning as translated there said, if you cannot hire an attorney, you have the right for an attorney to be assigned to you to advise you before or during the time that you are questioned.
Counsel?
Yes.
I sort of want to back up and ask him a little bit more of a broad question here.
Yes.
Article 3822, does that mention anywhere in the warnings affordability of an attorney?
It does. I believe it's the fourth warning, but one of the warnings in Article 3822 says,
Unable to employ.
If you're unable to employ an attorney, you have the right to have an attorney appointed.
But that's not saying affordable or you can't afford an attorney. That's just saying you can't employ an attorney.
Right, that's true, Your Honor. I think inherent in the word appointed is the idea
Right.
that, an attorney
Okay.
will be provided to you without
So
cost.
then this case really does come down to whether or not we think hire conveys appointed.
Right, yes, Your Honor. And so, yes, and what, as I'm sure this court is aware, what sort of courts look at in determining whether warnings are sufficient, is whether the warnings were the fully effective equivalent of the warnings that are required.
So you would agree then that fully effective equivalent is good enough for Miranda, not just 3822?
That is the language from the Supreme Court.
Okay.
Yes, Your Honor.
Did Mr. Acosta ask any questions at all? What, after his warnings, whether you think they were adequate or not, were read? Did he ask any questions?
He didn't, excuse me, he didn't ask any questions about the warning, but I would just remind the court that what the Supreme Court has said is that the Miranda warnings are an absolute prerequisite to the admission of a statement, and the court won't look to sort of other circumstantial evidence about whether somebody, they won't sort of engage in a sort of broader voluntariness or knowing inquiry about the waiver, but they simply look at the wording of the warnings and whether the warnings.
Well, to get
were-
to a knowing waiver, it would help if, I knew whether he asked questions or indicated he wanted a lawyer or anything like that.
Right, yes, and that is a separate issue, which we also raise in our brief, but this issue is strictly focused on the sufficiency of the warnings themselves.
Counsel, had
Yes.
Mr. Acosta been arrested before? Do you have criminal history?
He had been arrested before. He was arrested a couple of months before this and was given the Article 3822 warnings. There's a couple of things I would say about that. The first is the state provided a copy of those warnings in English, but they had the person who translated the warnings testify, but he testified that he didn't specifically remember translating those warnings for Mr. Acosta. And the state didn't provide any evidence about what those translations were, so there's no evidence in the record that he received effective warnings. And then I would also.
And you're talking about the arrest from 2 months prior to this incident?
Right, yes. And I will just say, the court in Miranda again said, the inquiry isn't whether there's other circumstantial evidence that the accused may have understood those rights. And I can read the court the language specifically from Miranda, which said, as with the warnings of the right to remain silent and that anything stated can be used in evidence against him, this warning, meaning the warning about the right to counsel, is an absolute prerequisite to interrogation. No amount of circumstantial evidence that the person may have been aware of this right will suffice to stand in its stead. So really, what the law requires the court to do is look at these warnings that were provided to him before this interrogation and determine if they were sufficient to apprise him of his right to counsel and what that entails. And I wanted to just talk a little bit about why the word hired is not the same as the word appoint. And so what courts will do when sort of evaluating the wording in given warnings is whether the words are similar or whether the word given sort of encompasses the word that is prescribed in the warning. So an example of that, this court in Bible versus State looked at a warning that said anything you say can be used against you in court, whereas the warning required the word trial, and determined that court encompasses the word trial, and so found the warning to be sufficient. But accused and appointed really are not the same in this context. Attorneys provided by the court are never referred to as hired attorneys. And you can actually see this distinction in the Code of Criminal Procedure.
It's not being used as an adjective. It's a passive voice verb. So will be hired, will be appointed. I think you need to limit the analysis to that context instead of using it as an adjective, don't you?
I think a part of the issue with this warning is it said you have the right to have an attorney hired.
Right, what's the first part?
If you cannot hire an attorney, you have the right to have an attorney hired, which I would submit in its totality doesn't make a lot of sense. But even if you pull out that language, have the right to have an attorney hired, hired is typically used to mean privately retained counsel.
But it's still, in the way that it's used, conveying to the defendant it's not his responsibility to get the attorney. Someone else is going to go do it.
Right, but I think what the warning has to convey, Your Honor, is that he has guaranteed right to counsel. So if you say you have the right to have an attorney hired, I think the most reasonable reading of that warning is you're also permitted to have somebody else hire an attorney for you. You could have a family member or a friend or some other third party hire an attorney for you.
But the purpose of Miranda warning in that regard is simply to make sure that an indigent defendant knows that he can still have an attorney even if he can't pick up the tab. Saying someone else might hire, suggesting that someone else might hire the attorney conveys to the defendant, doesn't it, that he doesn't have to pick up the tab for his attorney?
I think what Miranda requires is that the accused know that they have a guaranteed right to counsel and that it isn't contingent on them having the money for an attorney,
Well,
or them.
he's specifically told in the warnings, right, you have a right to an attorney to be with you during this interrogation.
He was told that, yes, Your Honor, but
Right.
then when he was told about how he could obtain that attorney, he was told you have the right to have an attorney hired. And I think that there wouldn't be any dispute that a warning that explicitly said, if you cannot hire an attorney, you have the right to have an attorney hired by your family, wouldn't be sufficient under Miranda. I think what the court was concerned about in Miranda was that the accused know that they have the absolute right to counsel present if they request counsel. And because the reasonable reading of this warning is just that he had the right to have someone hire an attorney for him, if you think about the sort of practical consequences of that, if you know you don't have anyone who's able to hire an attorney for you, then you effectively have no right to counsel at all, if you know that one can't be obtained on your behalf. And to say that you have the right to have an attorney hired also puts the burden on the accused to procure counsel, to find a way to obtain counsel. And again, if he has no way of doing that, then he essentially has no right to a lawyer. And I think this really kind of gets at the heart of what the court was talking about in Miranda and why it required that second warning, in addition to saying that you have the right to counsel, that the detectives also have to inform the accused that if they can't afford an attorney, they have an attorney for free. I can tell you exactly what the court said. Without that additional warning, the admonition of the right to counsel would often be understood as meaning that he can only consult with a lawyer if he has one or has the funds to obtain one. And the warning of a right to counsel would be hollow if not couched in terms that convey to the indigent, the person most often subjected to interrogation, the knowledge that he too has the right to have counsel present. And I think, sort of extrapolating from that, similarly here, what the Supreme Court has said
Right,
is...
but you've agreed that we don't have to have the exact words in these
Right.
warnings. They have to be the functional equivalent.
Right.
So all we need to make sure, or we need to decide is whether or not those warnings adequately conveyed to this guy that he has the right to an attorney, and it's not on him to get one, because one will be provided for him.
I would go one step further, Your Honor, and say that it has to be clear to him that he has a guaranteed right to counsel even if he can't obtain one. And that's where I think this warning and the use of the word hired in this warning and what the word hired means in the context of obtaining an attorney changes the meaning and
Well,
imposes...
obtaining isn't even appointing, though. Right? You're using obtain now, and obtain is much more open-ended and doesn't necessarily suggest to me appointment.
Right, and I'm not, I'm sorry, I just meant that the accused, that he doesn't understand that it's sort of on him to find a lawyer or hire a lawyer.
Right.
Sorry, I lost my train of thought, but
I do that to people. I'm sorry. I do it to myself.
But what I was saying is, the word hire, because of how it's used in everyday usage and also how it's used in the context of the Code of Criminal Procedure, really does change the meaning of the warning here. And I would also just point out, as it came up earlier, Article 3822 itself says if you can't employ or hire, we would concede that employ or hire are synonymous in this context, an attorney, you have the right to have an attorney appointed. And if those two words meant the same thing, the statute wouldn't have needed to draw that distinction and contrast them.
Right, but the reason why I asked that question actually goes back to, to go back to that, is that you're making a big deal about making sure that we convey, or that the warnings convey affordability, that the defendant can actually pay for the attorney, or if he can't pay for the attorney, someone else will pay for it. Well, 3822 doesn't say anything about paying for it, and that's in English. So like the implications of going with you might end up making 3822, and having to say that 3822 warnings are not sufficient under Miranda, which is a big deal.
May I answer that question, Your Honor? What I'm saying is that the right to counsel, what must be conveyed is that the right to counsel is guaranteed. So I I concede that the word appointed conveys that.
Okay.
That a lawyer will be provided to you without cost. You know, one thing that the case law does allow is for the court to sort of infer meaning from the words given. And so an appoint does convey that counsel will be provided at no cost to the defendant. And so I think 3822, the warning given there falls within sort of the rule that we're arguing that Miranda requires.
Was there a written statement?
There was just an oral statement given that was then transcribed. Yes. If there are no further questions, I will reserve the remainder of my time for rebuttal. Thank you.
May it please the court, opposing counsel, my name is Victoria Oblon, and I represent the state in this case from Tarrant County. The trial court properly found that the warnings given to Mr. Acosta prior to his custodial interview sufficiently complied with Miranda because they conveyed the essential meaning of the fourth warning and all of the warnings to Mr. Acosta.
Counsel, let me ask you this, because we keep talking about hire and then obtain, and obviously we're speaking English in here, and I only speak Spanish like a tired and hungry 3-year-old, but how confident are we that the words used in Spanish were, sometimes when you translate between languages, there's some meaning loss or you're approximating. How confident are we that there's a direct one-to-one relationship between the word hire in English and whatever the Spanish word is used?
So I'm very similar with you with my Spanish. I took Latin, so I am not attuned to Spanish, but the Spanish interpreter that interpreted the interview, he said that it was a word-for-word translation as close as he could. Detective Barakat, who was the one who read the warning card to Mr. Acosta, he said that he read it verbatim from the card. So as far as what the record is, those are kind of what we're working with. And in the interview itself, Mr. Acosta was not given he did not read the warnings. He was not given a printed copy. It was just read to him. So I think given the verbal translation and the translation in the transcript, and the fact that the defense is not arguing against the word hire, or I think their interpreter interpreted it as employed, but there's no substantial difference, and they're not arguing that there's a substantial difference, we can rely on what the record translation is for this case. And I think talking specifically about what a particular word is and what it means, I think we kind of need to take a step back when we're looking at this analysis. As has been pointed out from several judges, when we're looking at the Miranda warnings, they do not need to be a word-for-word recitation of the Miranda warnings outlined in Miranda v. Arizona. Rather, they need to be the fully effective equivalent or convey the essential meaning of that warning. And I believe my opposing counsel has added some additional elements that it's the state's position are not required as far as affordability, as Judge Knoll pointed out, and things like that. All we need to look towards is Miranda for what the essential information of this fourth warning is. In Miranda, the court stated that this meaning, and I quote, must, quote, convey to the indigent, the person most often subjected to the interrogation, the knowledge that he too has a right to have counsel present. That is the essential information that the Supreme Court in Miranda said must be conveyed through this fourth warning. Supreme Court cases since Miranda have not expanded on this fourth warning. The cases that deal with it, the fourth warning particularly, focus on the timing of the counsel, and it must be made clear that the counsel may be present for that specific interview and not tied to some future point. That's California versus Prysock and Duckworth versus Egan. That was really the concern there, that it must be excuse me, during that present interview. And this—
Counsel, doesn't that suggest that maybe using the word hire conveys some idea that the person, even if someone else is going to go hire an attorney, that someone else is going to go out there and shop for an attorney, and so it's not going to be present. That person's not necessarily going to be present because if he can't afford it, he'll have to wait to some future date to get someone hired.
Except that didn't this warning include the language before or during the interview?
It did, yes. And when we're looking at the warnings, we look at the entire warning that was given, which, as Judge Noel, you pointed out, he was first warned, the third Miranda warning, you have a right to an attorney present to advise with you during any interview. And then the specific language of this fourth warning, if you cannot hire an attorney, you have the right to an attorney hired to advise with you before and during the interview. And the Supreme Court said in Moran versus Burbine that the purpose of these Miranda warnings in their totality are to give some power to the defendant. He did not need to, Mr. Acosta did not need to continue with that interview, regardless of how long it took to get him an attorney. It was really that he did not have to proceed with the interview if he did not have one present at that time. And this requirement really does make sense when we look at the purpose of the Miranda warnings. They are to protect the suspect's Fifth Amendment right against self-incrimination. They are not a protection for the Sixth Amendment right to counsel. They are procedural safeguards for the right against self-incrimination, and that is why they have the right to counsel at that interview, even if the Sixth Amendment right to counsel is not attached yet, so that they don't incriminate themselves. And that's why the defendant has that power to stop the interview until he has counsel with him. Under this framework, this court's holding in Darden v. State makes sense and properly applies this the meaning of Miranda under this fourth warning. In that case, the juvenile was advised that if he could not hire or afford an attorney, that he had the right to have one present with him during the interview. And this is exactly what this fourth Miranda warning requires. Moving to an analysis, now with kind of that background and framework of the Miranda warnings, analysis of the warnings here, we look at these, and the Supreme Court said in Florida v. Powell that we, as I said, consider the entire warnings that were given, and we view them as a reasonable suspect in a custodial setting would view them. And I think that that is important. In my brief, I believe I pointed out the reasonable person standard, but having reviewed more for argument today, it does go further than that. It's not just a reasonable person out on the street, hey, what does this phrase mean to you? It's a reasonable suspect in a custodial interrogation, and what would the meanings in their entirety mean to that person?
Can I just interrupt you? Just
Yes.
to satisfy the chronology of this is the suspect is arrested, he's taken to the police station, he's a Spanish speaker. Is he initially Mirandized in English or Spanish?
Spanish. He was.
And then is the officer reading from the back of a card, or is he just speaking to him based on his Spanish knowledge?
So Mr. Acosta was spoken to both in English. The lead detective, Detective Gilden, spoke English entirely, and there was Detective Bearcat was speaking Spanish.
Okay. And were the Miranda warnings read to him from a card, or were they given to the suspect because the officer was fluent in Spanish?
They were read from a card, the Arlington card, and that's in the record. Reporter's Record 38-5 has the entirety of the warnings. It has all three of the Arlington cards. The second one on that page is the one initialed by Detective Bearcat that was read. And as I mentioned earlier, he held the card and
so
read it.
when the card was read to him, is the mistake of hired versus entitled or whatever in the card, or was it just an oral communication to him that was subsequently interpreted by the interpreter?
Well, I would say, one, that it wasn't a mistake. It was the verbatim reading of the card that was provided.
And was the card properly, then it was not properly written in Spanish?
The Spanish was what that card.
Okay.
Our position is, it was not necessarily a mistake. It was just that was the word that, when it was translated in that particular setting, was used.
And then was the card subsequently interpreted during the jury for the benefit of the jury?
The card was not. As I said, Mr. Manuel Murillo was the state's interpreter, and he transcribed the entire interview, the oral recitation of what was on the card. Detective Barakat testified on the reporter's record, page 30, page 20, that he read verbatim from the card. So the Mr. Murillo's translation of what was verbally said to Mr. Acosta would then impliedly be the translation of what was on the
Is
card.
the card in the record?
It is.
Okay.
Yes.
Is there anything in the record that sort of gives an opinion or gives an opinion that in a perfect world, this is what this card would actually say that everyone would agree complies with Miranda? I mean, obviously we're arguing about whether or not the words used here comply with Miranda, but is there anywhere in the record that says, you know what, this verb that they used here, probably not the greatest verb in the world, we should have used a different verb? Is there anything like that?
There was argument by both the state and defense counsel around that word, and at the suppression hearing, the defense called an attorney to testify about appointed versus hired and what it was that defense attorney's opinion needed to be required, but outside of that, nothing from the trial court specifically.
And then is there anything in the record about who actually created the card? Like, I mean, obviously not the physical piece of paper, but like the word, like who crafted the language in the card? Is there anything in the record about
The
that?
only thing in the record is that it was a card provided by the Arlington Police Department.
Was the recording of the interview offered into evidence? Is it in the record?
It is in the record. There are actually several versions. I have a footnote in my brief about it, but I will say Exhibit 303, State's Exhibit 303, is the entirety of the interview with no subtitles. State's Exhibit 304 is the entirety of the video with subtitles. And then I believe there's two more that were actually admitted during trial itself. I think it's 305 and 306 that were redacted versions based on some evidentiary issues that are not relevant to this point of error.
Thank you.
Since you're reeling off the numbers, what's the number of the card? Do you know?
The card was State's Exhibit, I believe it's 3, but it's in the record at 38.5.
Thanks.
Reporter's record 38, page 5.
Okay, thank you.
And the translation itself, again, it's in my brief, but just for purposes, it's in 38, it's at Reporter's Record 38 at 142 through 143 is the translation.
How much deference, so two-part, I think. How much deference do we owe to the translation given by the translator? Or, I mean, in other words, here's why I ask that.
Yes.
Because in the absence of some evidence that whoever crafted this card did so in bad faith, is that not some indication that if a person was translating the warnings that were supposed to be given according to Miranda, that they were doing their level best to try to translate those words into Spanish as that person understood it? So you understand what I'm saying?
I do.
Yes.
And I think there's no evidence, as I said, about who actually created this card. But Detective Barakat did testify at the suppression hearing that it's not always possible to do a Spanish a word-for-word translation from English to Spanish, and that when that's not possible, you kind of get the best that you can. And so, with Detective Barakat's testimony on that, I think the deference would be applied more towards the trial court's taking of that information and viewing of that evidence, which under a motion to suppress standard, which is what we have here, this court would give very strong deference towards the trial court accepting that testimony and how the card was presumably created, and then we apply a de novo standard of, okay, these are what the words are towards the Miranda application of those. But I think the creation of the card and Detective Barakat's testimony, which was impliedly approved and accepted by the trial court, is entitled to great deference.
One more kind of nuance on that is, I'm thinking for some reason I think about a lot of things at once, right?
I understand, yes.
The Supreme Court of the United States, I think, not long ago said something about, in the death penalty context, if you're going to argue that a certain form of execution is unconstitutional under the Eighth Amendment, then you have to point out an alternate means of causing your death that will be less cruel, right? As sort of a burden. And so I'm wondering if in a context like this, if when you get into a debate about the meaning of words that are being translated from one language into another, is there any burden on the person objecting on the ground that the words were not translated correctly to show a better word?
I think that that's a very interesting question. I don't know per se a burden, but what I can say is in this case, the defendant had the opportunity to do so, and they presented a defense attorney as a witness to discuss the warnings, and that witness, and I don't have a record site for this one, I apologize, but that witness testified. I don't know what the appropriate word for either a free attorney, I believe they were talking about. I don't know what that would be, but I can tell you that it's not there. So if there is such a burden in this type of case, that burden was not met.
Counsel, just to come back to something you said very earlier, though, we all seem to be in agreement that this English translation of "will be hired" is what everyone's agreeing that we're supposed to be analyzing under this standard, right?
Yes.
So that's what no one is disputing that that's the language, and that's what we have to interpret.
Correct.
Okay.
That is correct. Yes, and that is going towards that translation and why it is sufficient even to advise Mr. Acosta of his rights. And I think it has kind of been pointed out throughout argument when we're looking at these warnings under the view of the reasonable suspect in a custodial setting, they really do advise Mr. Acosta that he has the right to his counsel, to counsel during the present interview. Specifically, you have the right to have that phrase in and of itself. This is not permissive language. It is not something that could be taken away. It is a right that he has, and he was advised of that twice. You have the right to have an attorney present with you, and then again, if you cannot hire an attorney, you have the right to have an attorney. And this is different than some of the cases that were cited in the defendant's brief that were insufficient under the fourth warning that used permissive language or suggested that the defendant could be denied right to counsel at this interview. In those cases, Ohio versus Ramirez and Perez versus Lopez, U.S. versus Perez versus Lopez, they used terms like solicit an attorney or petition the court for an attorney, and didn't have either a temporal connection to that or, as I said, they implied that it could be denied. That's not what we have here. Very clearly, 2 times during the warning, Mr. Acosta was advised, you have this right to have an attorney. Again, Mr. Acosta was also advised that he could have one hired. This takes the onus off of him. Someone else is going to be doing this. And when we look at this phrase in the custodial setting, which is what we are supposed to do under the Supreme Court's precedent, it is reasonable to conclude that if it's not his burden, his responsibility, then it is most likely the person reading him this warning, the government, is going to be the one doing the hiring.
But counsel, isn't it, I mean, to the appellant's point, isn't it possible though that someone could hear that warning and think, I now have to get, like, they would not foreclose the possibility, they'd have to get a friend to go hire the attorney, they have the ability to have a friend go do it, instead of being told, this is going to be provided for you and paid for by the government?
I mean, I think I would agree a very more direct, clear advisement would be, we would prefer that, optimal, yes. However, that's not what's required. As we talked about earlier, as I talked about earlier, in Miranda, the court specifically said that this fourth warning must convey to an indigent person the knowledge that he has the right to have counsel present as well. And whether that individual believed there was maybe some other things he had to work with, he still was informed that he had the right at that present interview.
Counsel, you mentioned earlier that we're supposed to look at this from the point of view of a reasonable person in custody, and sort of following on what Judge Newell said. I mean, if the appellant here is a foreign national, I mean, how much do we take into account maybe his experience with law enforcement in another country, or maybe he thinks, well, in other countries you got to go get your own lawyer, and so when they say someone will be hired for you, maybe he's thinking. I mean, is there any place for us to consider sort of subjective factors from his point of view in regards to this being in custody?
I would agree. I believe my opposing counsel answered a similar question. In the voluntariness and knowledgeable waiver of the rights, I think that's the appropriate avenue to consider this specific defendant's ability to, whether he understood it and they in fact raise this similar issue as part of their voluntary and knowing waiver of the issue. But when we're just looking at the words, we just take the reasonable suspect. And to more address that point, I believe in our brief we do argue and stand by the position that because of the specific defendant's prior history with the American criminal justice system, having been advised of his rights just months before, this specific defendant did knowingly and voluntarily waive his rights regardless of the warnings here. And there's no further questions from the court. I believe the trial court properly concluded that the warnings provided to Mr. Acosta were sufficient under Miranda. We would ask this court to affirm that holding and the remaining points of error in this case. Thank you.
counsel.
I have just a couple of brief points I wanted to make on rebuttal. Judge Urey, with regard to your question about some burden being on the defendant, I just wanted to remind the court that the law is clear, that it's the state's burden to prove that that the procedural requirements and safeguards of the statement were met and that the statement is admissible. So there is no burden of proof on the defendant to prove that that there was some other adequate warning. What is required is for the state to prove that the warnings were adequate. And what we have here is the state's translation. Also, with regard to the question about the standard of review, what this court has said is when there's a mixed question of law and fact and there are no credibility determinations here, and the trial court didn't make any credibility determinations, that it's a de novo standard of review, and that is the standard of review we would submit is appropriate for this point of error. And then finally, I just wanted to return sort of again to what Miranda requires and be really clear what that fourth warning in Miranda about providing appointed counsel, what is inherent in that word appointed is that the government will provide counsel. So a warning that informs a defendant that someone else could hire counsel for them is not sufficient under...
Without identifying who that other person, yeah.
Right.
The passive voice leaves open to any number of possibilities, and it doesn't clearly convey that the government's going to...
Yes, exactly. So, Your Honor, if the warning had said you have the right to have an attorney hired by the government, we would say that that warning is sufficient. But because this warning just said hired, and that term in particular, not only is that another sort of plausible interpretation, but I would submit as the most reasonable interpretation because we don't typically talk about the government hiring lawyers. We talk about courts appointing lawyers, but words like retained, employed, hired typically refer to the private retention of
So
counsel.
you disagree with the state, I assume, that the focus of the warnings is to let the accused know that he has the right, hired, brought in from outer space, wherever, to have someone present during the interview.
I would say that the purpose of the warning is to let the accused know that he has a guaranteed right to counsel if he requests one, and that that isn't contingent on his ability to hire one, on someone else's ability to hire one. I will say there's a U.S. Supreme Court opinion, California versus Prysock, where the court upheld the warning in that case, but said if there was a warning that limited the right to counsel to some future time past interrogation, that would be insufficient, and talked about not limiting the right to counsel. And we would submit here that the warning limited the right to counsel, and for that reason, the admission of Mr. Acosta's statement into evidence was error, and we would ask this court to reverse his conviction.
Can I ask one more question? So I can't remember the name of the case, right, as we, in the middle of this argument, but didn't the U.S. Supreme Court last term have an opinion where they basically said that the Miranda warning requirement isn't, strictly speaking, a constitutional requirement. It's a prophylactic designed to enforce the constitutional rights at issue. Does that opinion have any impact on your case, do you think?
I don't think it does, Your Honor. That, I know the opinion you're talking about. I can't remember the name off the top of my head, but that was an opinion about whether failure to give proper Miranda warnings give rise to a 1983
Right.
civil claim,
Right.
which is a very different inquiry than whether the prophylactic warnings are required in a criminal case for somebody about to undergo interrogation. And this court certainly has continued to require warnings to be given. Last year, I believe this court upheld a trial court's granting of a suppression motion where a defendant wasn't given her Miranda warnings prior to an interrogation.
But the thrust of that case was to still emphasize that the constitutional violation is the involuntariness of the statement or the lack of.
Right.
Yeah, like if they give an involuntary statement because of the lack of warnings, then that might be something, and that's more akin to what you're arguing here.
That's true, Your Honor. That was the basis of that decision. But my point was, I don't think that there's any question that these warnings are still required for a criminal defendant undergoing interrogation. So if there are no further questions, we would ask this court to reverse Mr. Acosta's conviction and death sentence. Thank you.
Thank you, counsel. The case is submitted. Court will stand in recess for 10 minutes. Please be seated. Call now cause number PD 088721, ex parte Michael Lowry.
Good morning, and may it please the court. My name is Patricia McLean with the Harris County District Attorney's Office, and I represent the state in this case. The issue in this case is whether the Texas statute that criminalizes possession of lewd visual material depicting a child violates the Constitution on First Amendment grounds. And at the outset, as it's limited by the indictment in this case, Section 43.262 of the Penal Code makes it a crime to knowingly possess visual material that depicts the lewd exhibition of the pubic area of a clothed child who was under 18 at the time the material was created. The material must also appeal to the prurient interest in sex, and it must lack any serious scientific, political, artistic, or social value.
Counsel?
Yes, sir.
If this is just, your argument is that this is just child pornography,
Yes, Your Honor.
why did we even need the statute? Wouldn't this also be covered by the child pornography statute?
No, Your Honor. The specific section that's at issue in this case is the pubic area of a clothed child. That is not designated as sexual conduct under the existing child pornography
Is
statute.
sexual conduct an element of this offense?
No, sir, it's not.
How about the second element? How would you establish that or not?
The prurient interest?
Right.
Yes, sir. There is no definition of prurient interest. That was obviously pulled heavily from the obscenity statute, which does not define prurient interest. However, previous versions of that statute, make sure I get my words right, have defined prurient as a shameful or morbid interest in sex, and that was part of the definition of prurient at issue in Miller v. California. That was part of California's definition of their obscenity statute. And that's also in line, it's very similar to the standard dictionary definitions of what prurient means.
What about lewd?
Lewd is also not defined, Your Honor, but this court, in examining child pornography cases brought under 4326, have examined various factors to determine, in examining whether an image is a lewd exhibition. And those come from, essentially they're pulled from US v. Dost, and they deal with things like whether the focus is on a child's genitals, how the child is dressed, how they are positioned, whether the material is designed to elicit a sexual response, and all of those factors go into a determination in child pornography cases as to whether an exhibition is lewd, and the same standard would likely apply in this case, as the same terms are defined here as they are in the child pornography statute.
Counsel, didn't the legislature enact the statute to close a loophole that they saw within the child pornography statute?
Yes, Your Honor, that's correct. And they say that as much in the legislative materials and in the legislative hearings. They discuss that in certain instances, what they are designating as child erotica images, which essentially are images that do not fit within the current child pornography statute, that oftentimes when officers are investigating child pornography cases, collections of child pornography also include these separate types of images that are not covered under 4326. And in certain cases, only those lewd exhibitions of pubic areas or clothed children are found, and in those cases, charges cannot be filed, which is why this statute was enacted in the first place.
I have a question.
Yes,
I have to admit, after reading the briefs in this case, I went to the record as we're able to view it, and looked at the clerk. There's one document that we can look at called the clerk's record, and another one called a supplemental clerk's record.
Yes, sir.
And I haven't found yet, I'm not saying it's not in there, I'm just saying in the limited time that I gave to the matter so far, I have yet to see an actual copy of the indictment itself. But I did find a pleading that looks like it was filed by the state. It's called State's Response to Defendant's Application for Writ of Habeas Corpus, ex parte Michael Lowry. And it presents a different description of what the indictment actually said than what some of the briefs seem to suggest. And I'm wondering, is this document that I've come across, is this mistaken? It is?
Yes, Your Honor.
Oh, okay.
The state's response that was filed in the trial court, it discussed more 4326, which is the child pornography statute, and I believe it did mistakenly discuss what the indictment actually says. This case is a little unusual in that there were 2 cause numbers that initially went up on appeal. The writ was appealed, which is this instant case here, as well as an appeal in the underlying charge. And the indictment was included in that record, but for some reason wasn't shared with this one. But the parties do not dispute how the indictment is limited in this case.
Well, I mean, it causes me, I'm really curious because it seems to me like depending upon what he's actually charged with, it could make a difference in how we might analyze the issues that are being presented to us. And this says nothing about what's the phrase I'm looking for? Pubic area is not mentioned in this language that seems to be a quote from the indictment.
And that pleading is incorrect, Your Honor.
Okay.
It is incorrect. It was correctly cited in appellant's writ. It was also correctly cited in the briefings on appeal and in the briefings to this court, Your Honor.
Okay.
The state's response was incorrect in that indictment in that. Yes, sir.
Counsel,
Yes, ma'am.
in the conclusion of the Court of Appeals opinion, they say, "We hold that the portion of Section 43-262 of the Texas Penal Code addressed herein is void." How broad is that holding? Is it just for clothed children?
Yes, they did expressly limit their holding to depictions of lewd exhibition of pubic areas of clothed children.
Thank you.
Yes, Your Honor. And since we were talking about the child pornography, I'll just jump back into that a little more. While this statute is not part of the current child pornography statute, when you look at Ferber and their analysis of what child pornography is, what interests they serve, and what requirements child pornography statutes have, 43.262 satisfies all of those requirements. It designates...
That actually brings me to a point, like, because I remember that part in your brief, and one of the things that you say is that this statute, you argue that the statute specifically prescribes particular conduct or something like that. I'm like, how? I mean, all this is just possession of a photograph of clothed pubic area. It's not like there's nothing about the DOS factors. We're not even limited to sort of obscenity. So how is it that you explain to me how this prescribes specific conduct?
Yes, Your Honor. It prescribes specific conduct because it specifically lays out not just lewd images that would be illegal if they are possessed. The statute specifically states they have to be lewd exhibitions of certain bodily areas of a child under a specified age, that the child is clothed, that they appeal to the prurient interest in sex, and that they have no redeeming or no serious social value. And all of those together are clearly define what type of images we are talking about here. As this court has been able to do in the past, when they look at child pornography cases, they are able to apply what lewd actually means in a standard child pornography case, even though lewd exhibition is not defined in the existing child pornography statute. So though it is not sexual conduct under the sexual performance statute, which is what dictates, which is what controls the child pornography statute, or 4326, lewd exhibition of the clothed pubic area of a child is sufficiently definite and specific to describe what type of exhibitions are being outlawed here.
Thank you.
Alternatively, even if this court disagrees that 43.262 is limited to material that is properly considered child pornography, the Court of Appeals failed in holding, or they erred in holding, that the statute failed strict scrutiny. The Court of Appeals, essentially, they did recognize that there is a compelling interest in protecting the well-being of minors and preventing sexual exploitation and abuse of children. However, the Court of Appeals determined that since these images do not fall in the current child pornography statute, that they can't be child pornography, and therefore there is no nexus that was shown between these images and that compelling interest.
Isn't the statute, though, capable of applying to situations that are not just going to be child pornography? Like, can't the statute apply beyond the contours of pornography?
Your Honor, respectfully, I would contend that
when you look at all of the factors all together in how this statute is limited, that those depictions necessarily would be sexual exploitation and child pornography. However, in the event they may not be considered child pornography, they are nonetheless necessarily exploitive given all of the elements that are required to be satisfied by the statute. And in that case, where the
So
court...
it's so those situations would still be protected speech, but it would still satisfy strict scrutiny.
Yes, sir, because it is so narrowly defined. It's not just lewd exhibition, period. It's not just of certain areas. It's very specific about what type of depictions we're talking about, that they have to satisfy the prurient interest and have no serious value. And all of those together, if there is an image that satisfies all of those elements, it would necessarily be sexually exploitive.
Does Cuties have artistic value?
Your Honor, I have not watched it, and that would be an issue for the trier of fact in that case.
That's a good point.
Last I checked, they have now, I believe it's charged now with sexual performance, and that the indictment under 43262 was dismissed, and it was never reached as to the constitutionality in that case. In its strict scrutiny analysis, when the Court of Appeals essentially held that there is no showing or there is no proof that these types of lewd images are exploitive or are a problem that needs to be solved, what the Court of Appeals essentially did was draw an arbitrary line between what constitutes impermissible sexual exploitation of children or sexual abuse of children and protected speech that's fine. But as we know, even under our current child pornography statute, child pornography is not just defined by the types of areas of children that are depicted, nor are they limited to depictions of children who are nude or not clothed at all. Certainly there could be images where a child is clothed performing sexual acts that would obviously be child pornography. And just as so, there could be images of different areas, like Texas's statute also applies to images of an anus or the breast under certain areas, and that is not covered under Ferber, but no one disputes that that is properly considered child pornography. So when the court designated that line, that was an arbitrary line that doesn't satisfy the right interest in what we're actually trying to protect with this statute. Moving on to the overbreadth challenge, the first court held the statute was overbroad under the overbreadth doctrine. However, the court erred in even addressing that point in the first place because it wasn't properly preserved in the trial court. And alternatively, even arguing for the sake of argument that it was preserved, the trial court still erred in its holding because there was no showing, appellant did not meet the burden to show substantial overbreadth.
Let me just ask, in Bowles, you had an image that was arguably artistic and perhaps pornographic. I'm a little bit confused on this statute and how the appellate court ruled. What is the distinction between partially clothed and a clothed child in the context of determining whether or not this is lewd visual material? What's showing, what's not in those two examples?
And Your Honor, I believe that would be an issue for the fact finder as to what constitutes partially clothed. That is not defined in the statute, but as applicable.
How about clothed?
Sorry?
Clothed.
Just the general, fully clothed. I would assume for the sake of argument, opaque clothing. I would argue in a bikini that is clothed. You could go out in public and be clothed.
So if it's clothed,
Yes.
for purposes of that statute, or if they're clothed, how do you get to the point where it could be defined as lewd visual material for somebody under the age of 18?
Yes, Your Honor. And that's actually part of, it actually increases the state's burden to show lewdness for pictures depicting clothed children. Obviously, something would have to be a little, since full genitals are not on display or other body parts aren't nakedly in view, the court would have to look at other factors to determine, is this a lewd image? And then essentially raises the state's burden to show this image of a clothed child is in fact lewd. Your Honor.
Would this cover, I mean, I was just thinking about this too as you was asking the question. What about like the cover for Smells Like, or for Nevermind by Nirvana? Like, that's got a baby, and you can see his genitals. Is that going to be the kind of thing that will be criminalized under the statute?
No, Your Honor. Again, you would have to go to the serious artistic and social value. That prong is also at play in this statute, so that would be an issue for the fact finder to determine there. And as to lewdness, considering the dose factors of what is, is it zoomed in like the situation was in Bowles? Is the child being posed in a sexually suggestive manner, which in that cover, he was in a baby in a swimming pool. So those factors would also come into play to determine if that is a lewd exhibition or not.
Counsel, quick question. Opposing counsel says a few times that he's concerned, he has not watched certain videos because of the concern of possibly being prosecuted for watching, for this offense. What's your answer to that?
My answer to that is, if I may briefly answer, it's essentially in two parts. If there is an overbreadth challenge that was preserved, that goes towards a showing that appellant did not meet his burden to show this is actually a substantive problem. No one's asking him to look at lewd photos or anything like that, but there's no studies, there's no rules or reports that were cited by appellant showing that images that fit this specific statute are just rampant on the internet. That's just not there. And I believe I lost my second point, Your Honor, but I may come back and rebuttal.
You can come
I'm
back and tell me later. Thank you. Thank you, counsel.
Good morning, and may it please the court. I'm Jonathan Landers, together with Neil Davis. We represent Mr. Lowry. We're also from Harris County, Texas. I'd like to start off just addressing an issue that you discussed, Your Honor. There's two underlying cause numbers in this case, and the way they have us file in Harris County is we file our habeas application in the underlying cause number, and then they'll create the second cause number. In both clerk's records, the habeas application appears. That is why we specifically appealed under both cause numbers. Whenever the clerks moved the habeas application to the new cause number, they did not include our appendix. Our appendix has not only the indictment, it also has some other information that the court considered and that we argued about. At the hearing, we specifically had the trial court take judicial notice of that underlying clerk's record. So it is part of the record, and it's also before the Court of Appeals. And so if there's anything we need to do to get that up here for you to review, I'll make sure I do that. So everything you need is in the record, just so that we're clear on that.
Thanks.
Secondly, Judge Newell, you mentioned earlier sexual conduct a part of this statute. And as I've been reviewing for this argument, it occurs to me that that's a very important question because
I'm glad I asked it.
well, not only is sexual conduct part of the child pornography statute, the child has to be engaged in sexual conduct. It's also part of the second Miller prong. The second Miller prong is things that are patently offensive and that relate to sexual conduct. Whenever we remove the lewd exhibition of, in this case, clothed pubic area, under that umbrella of sexual conduct, that's when it loses its meaning. An example that I came up with, if I went to a high school football game with my grandfather, we looked at the cheerleaders and I asked him if he thought they were being lewd, he'd probably tell me yes. If I asked him if they were involved in sexual conduct, if I didn't get slapped, he would probably say no. That umbrella is what protects these types of laws, like in Miller, in Ferber, from the First Amendment, because we have, for child pornography, juveniles that are involved in sexual conduct. Then we have a kind of catch-all there, which is, in Texas, the lewd exhibition of genitals. All right, now, the definition is also changed. We don't do the lewd exhibition of genitals. In this case, it's lewd exhibition of the pubic area of a clothed child. But
even if it's fully clothed, is that the ruling of the Court of Appeals? That it could potentially be lewd material even if that area of the body is fully clothed?
that is what is so confusing about the statute, quite frankly, is we're trying to figure out what is a lewd exhibition, in this case, of clothed pubic areas. And the state's brief before this court really hinges on one idea, which is this law, as they've said, essentially only outlaws child pornography. Now, clearly, if the law only outlawed child pornography, then it would pass muster under the First Amendment, but there's just too many problems with that argument. First of all, Ferber tells us that child pornography is limited to things which show child sexual abuse or harm children. It's a very limited category. We allow those types of laws to make sure that there's no incentive for people to abuse children. But as we've seen from the Netflix prosecution and the ideas that I've come up with, and that we presented to all the courts, such as Instagram models that are under the age of 18. Before this court, I've learned about TikTok. Apparently the same thing's going on there. You know, you have older teenagers who might be dressed in somewhat scantily clothed, dancing, taking pictures, selfies of themselves. But if that is lewd, which I think appeals to the sexual interest, then that person could be prosecuted along with anybody that follows them on Instagram or lives in Texas. It's from getting outside of that sexual conduct requirement that the law becomes much too broad, and also allows the courts to look at it in the First Amendment light. I'd also point out that the legislative history, the original version of this law, and that's included in our briefing. You'll have everything you need in the other clerk's record. The original version of the law specifically applied to obscene material that was also child pornography. I don't know why we needed that law. It included the DOS factors, and the state has provided us with a link to some of the argument before the legislature. If you click on that first link, the gentleman who's discussing the need for the law is mistaken. He thinks that the DOS factors have not been accepted in Texas. At that time, they'd been accepted by the Court of Appeals already, numerous courts of appeals, for maybe 20 years. And just a few weeks after that, I think it was in Bowles, the case that was mentioned, this court noted that these DOS factors have been around in Texas for many years. It wasn't necessary at that time. So what the legislature was intending to do originally must have been either to just simply outlaw child pornography, and it was limited to child pornography because of those DOS factors, or they were, if these 88 cases the guy mentions in that little clip really couldn't be prosecuted under child pornography, then those are protected speech. Because once we get outside of obscenity, once we get outside of child pornography, we have protective speech. I don't know, there's no reasoning for why the final version of the law was changed. All that I can come up with is someone realized we've already got obscenity statutes, we've already got child pornography statutes. If we're going to close some loophole, we've got to make it more broad. And that's our problem. And this court has looked, I think the Thompson case, the improper visual photography case, this court has looked to the fact that we already have statutes prescribing certain speech when trying to figure out what it is that's going on in the statute at issue.
Counsel, you mentioned earlier that this is a very broad statute. What the state argues that you haven't preserved your overbreadth challenge. What do you say to that?
Okay, so I think you looked at this court's recent decision in Nuncio, which makes it clear that we have preserved the issue in this case. Before the district court, under the heading of overbreadth, we argued and we cited Ex parte Low, we cited the relevant Supreme Court case law, we cited the exact test that the state claims we needed to cite, word for word, in that briefing. We gave examples for why this was overbroad. It was the Instagram influencers under 18. I found a news article about these young ladies. So we certainly preserved it. We went further than the applicant in Nuncio did, I'm guessing based on the opinion. So I don't think that there's any doubt whatsoever it's been preserved. I would also point out that the state's reply briefing, although it discussed a different indictment and different statutes, it almost exclusively addressed overbreadth. And if we hadn't raised the issue, they wouldn't have been arguing. Before the district court, we had a brief hearing on Zoom. Both parties discussed overbreadth doctrine, and then the district court denied the entire habeas application, later did it in writing at the request. It was actually denied. It was written out denied originally, but the Court of Appeals, out of an abundance of caution, sent it back down for a one-sentence written order.
Is it just legal arguments or testimony at the district court?
It's just legal arguments. Okay. In addition to the judicial notice of the underlying clerk's record, and also we'd filed that supplemental notice about the Netflix indictment, which we thought was just, and that entire briefing that we'd filed was about overbreadth and about how if they're charging this company out in East Texas, it really establishes our point. The judge also took judicial notice of that indictment at the hearing, but there's no evidence put on whatsoever. So to answer your question, the issue's preserved, and I think the Court of Appeals got that correct. I think that no one disagrees this is a content-based restriction because we have to look at the images or the visual material to see what's going on, so we have to look at strict scrutiny. So the Court of Appeals was correct that I think everybody agrees that there's a compelling interest in protecting children. In reviewing the issue de novo, though, the Court of Appeals pointed out something which is very interesting, and it's correct. For strict scrutiny, the state has to identify an actual problem. And although we're not real sure what lewd visual material is, in this case,
Well, counsel, isn't one definition of lewd obscene? Like that's a synonym for lewd.
the definitions that I've seen have been more along the lines of sexually unchaste, inciting lust.
Unchaste, yeah, but that's right. But it's offensive and usually in a sexual manner, and a synonym for it is obscene. Does that render this statute capable of a narrowing construction or not?
In that the court would try to render it, make
Well,
it
we
only
could
obscenity?
does the court have the ability to interpret the statute according to the way the state says and say this only covers child pornography, something that would satisfy the DOS factors?
I don't believe so, because the Thompson case tells us, also I think Ashcroft, the Supreme Court case, tells us that we only do that when the statute is
Capable.
is susceptible to a limited
Right.
instruction. One of the issues here is we originally, as introduced, had a statute that was both outlawing obscenity and child pornography. So if the court were to attempt to do that, you're stepping into the shoes of the legislature right there. We don't know why they did it, but we do know they did not intend to outlaw either obscenity or child pornography because they removed those DOS factors. I would also respectfully disagree that lewdness necessarily meets the obscenity test as laid out by Miller, and that's the error the trial court made. You know, the trial court said, look, if something is going to be a lewd exhibition of the pubic area of a child, it meets the Miller test. But Miller has specifically laid out those elements. The Supreme Court has made clear we can't skip one. The Supreme Court has made clear that third element about, value, societal value, does not save a statute. So to answer your question, I believe it would be improper to limit the statute to only child pornography.
The reason I say that is, the reason I ask that question though, is that when I see cases talking about it's not susceptible to a narrowing construction, you're really having to write in sort of terms and things like that. But this is really just defining the word lewd. And if we're defining the word lewd as obscene as meaning obscene.
I believe that, so we've got both lewd here, and then we've got the first Miller prong, right? I think they're basically the same thing. Pure interest, lewdness, I don't know the difference there. I do believe that the court could try and define lewd in that way. I don't think it's the only definition, but I think the problem would be that the court would be doing something that the legislative history makes clear.
I got you.
That's not what they were trying to do. I mean, it would be a violation of the separation of powers to do so.
If the court concludes that the statute is capable of some applications in which the First Amendment is not violated, then I think we could ultimately get to the question of whether, if there is some realm of overbreadth in the statute, we'd have to make a determination about whether it was, I think the term is substantial in relation to its overall breadth.
Right.
And that's an area in which you can enlighten me, maybe, because I frankly struggle with that quite a lot. I mean, I jokingly say that even the Supreme Court's own opinions on overbreadth are kind of vague.
I agree.
Because, I mean, I don't know whether that means any possibility at all that it might be applied in violation of the First Amendment, or whether it might be 10 different ways that it might be, or whether it means 90% of the time, or whether it means 10% of the time. I'm not sure exactly whether they've given us a good answer on that yet. And if they have, I hope you can let me know about it. And if not, maybe you can give me some principles upon which to start to discern the meaning. I mean, I know that in addition, it might be, I mean, the Court of Appeals said, they quote Stevens from the U.S. Supreme Court as saying that it's likely to be found overbroad if it is alarming breath. I mean, again, it could be alarming to someone if it happens one time, if it's possible that it could happen one time. And I don't know whether the precedent or if there's any precedent that gives any flesh to the question that needs to be answered there.
Well, the test is that it's, regulates protected speech in a substantial number of its applications, considering its plainly legitimate sweep. So the first thing we have to, I think, decide is what is the plainly legitimate sweep here? Right. I think the only plainly legitimate sweep is if it involves child pornography, and we agree this statute does. I mean, things that are child pornography are most likely going to fall under this statute as well. Okay. So we have to ask, what else is it going to reach? You're correct that the Supreme Court precedent's all over the place. In one of the cases, Free Speech Coalition, they simply said, well, look, it doesn't pass the Miller test. It's not child pornography. They didn't even discuss the overbreadth, hardly at all. They gave a few examples, and then they just said it's overbroad. I think that it has to be more than that, and that's quite frankly the task that the court has to decide on the overbreadth issue. I would point out that this law would, let's just say there's one instance. Let's say that that movie Cuties falls under this statute, but not the child pornography statute. One thing that's interesting about that is it would not subject only Netflix to prosecution. It would subject anybody in Texas who's watched that movie, potentially anyone that has Netflix and therefore might be said to have possessed
Watching it,
this.
possessing it?
Well, it's not only possession, it's, I'll grab this. In this case, it is possession, but just generally so that we know, the statute is.
Access with intent to view, right?
Access with intent to view or promotes. So, I mean, speaking about it, numerous different things. The statute as far as, so that answers that question. I don't know exactly what the test is. One incident would not be enough, but in this statute, it's going to have a far reach. I think it also does reach, like I said, the Instagram influencers and high schoolers sending clothed pictures, but maybe seductive pictures to each other. We also, this kind of bleeds into the narrowly tailored part of the strict scrutiny test. This statute, we argue, doesn't have a specific mens rea like the child pornography statute does. That was actually taken out by the legislature, so we don't think it'd be proper to read in. And secondly, it doesn't have any of those exceptions for child pornography for law enforcement, for teachers, for people who are trying to correct problems. Long story short, we think that the Court of Appeals got it right, that this statute is content-based speech, doesn't pass the strict scrutiny test, and is overbroad. We certainly think it was preserved, and we'll make sure the court has the complete clerk's record. If there's not any other questions, then we'll see the rest of our time.
Thank you, Ken.
We ask that you affirm the Court of Appeals.
Just very briefly in rebuttal, I want to jump right to the overbreadth since that took up a lot of counsel's time and this court's attention. And I want to start with preservation. Appellant argues that because he stated the overbreadth test in his initial application and because the words overly chill speech came out during the hearing, that is sufficient to preserve a challenge under the First Amendment overbreadth doctrine. And the state would posit that's just not the case. That's not sufficient. And moreover, what happened in this case, which also further differs from what happened in Nuncio, is that in the hearing in this case, the state's response did incorrectly address overbreadth, but then appellant argued to the court that that was incorrect. That was not the challenge. He affirmatively rejected that he had the burden to show substantial overbreadth, which is the applicable burden under the overbreadth doctrine. When he did discuss overbreadth and overly chilling speech, it was in the context of the vagueness, his vagueness challenge, which was preserved. But vagueness is even farther afield from a First Amendment overbreadth doctrine challenge than a traditional challenge, which involves scrutiny. Vagueness is a Fifth Amendment doctrine, and it has to do with whether a statute is clear enough to even provide adequate notice to citizens and to law enforcement. And while under the First Amendment, if a statute does implicate the First Amendment, there is an additional prong of a vagueness test to make sure that a statute is sufficiently specific to avoid chilling protected speech. And to that extent, that is the correct part of a vagueness test, but that is not the same as a challenge under the overbreadth doctrine, which the overbreadth doctrine was designed to essentially let defendants jump over a standing requirement and complain that a statute, not that it's unclear, but that it applies to too many, if there's too many impermissible applications to other people. A traditional challenge essentially looks at the what question of what is the scope of the statute, what material or speech is being prohibited, is that scope narrow enough to achieve the compelling interest, and is it necessary? By contrast, an overbreadth challenge it's conceding there is a legitimate sweep to the statute, but the statute still applies to far too many third parties, and that is what makes it unconstitutional and why a defendant can challenge even though they lack standing, as it applies to other people. And that gets me back to my initial point to you, Judge Keller, about when counsel said he could not look at the images to determine if they actually satisfy the statute or not. That gets more into the issue of who this statute applies to. For example, the Instagram influencers or law enforcement or Good Samaritans who report these materials to the police. That issue of whether this statute improperly and impermissibly impacts them is more appropriate under an overbreadth challenge. That is more appropriate in an analysis under the overbreadth doctrine. And that just wasn't preserved in the case, as appellant affirmatively refuted that he was arguing overbreadth. I believe he said more than once in the record, that's not the burden, it's the state's burden to establish a compelling interest. Essentially, he lays out the strict scrutiny analysis and argues that the state failed to meet that challenge. So this goes even further than what happened in Nuncio. This isn't a case of simply attempting to argue overbreadth and maybe not doing it as clearly as one could. This is an example of affirmatively refuting arguing the overbreadth doctrine. It was not briefed on appeal. What was briefed on appeal, again, was the vagueness argument, and that has been preserved, and no one's contesting that. And so that is why the court erred in addressing overbreadth in the first place, is not that it was just insufficiently argued or maybe could have been argued better. It was affirmatively refuted that appellant said, we are not arguing that, that standard is wrong. And I believe with all that, unless there are any other questions, I'll see the rest of my time. Thank you.
Thank you, counsel. Case is submitted.
All right.